25, preterm labor.
Why is that there since it's already in the law?
Yeah.
It's redundant.
Because it requires a referral.
Huh?
Because it requires a referral. The statute doesn't say refer, it just says you can't do. I mean,
It seems obvious to me.
well, yeah, you would hope.
But why delete it? I mean, is there some harm in keeping it there?
Oh, yeah.
If it's already in the statute, putting it in the reg is unnecessary.
They will
And they'll
take issue with
I
it.
yield.
It's true. Alright, so I propose we delete it since it's already provided for, and that would be the same with 28. Alright, so 27, pregnancy with non-reactive stress tests and or abnormal biophysical profile or amniotic fluid assessment.
You missed 26.
The premature rupture of membranes is not in statute.
No, that should be there.
That should be in.
Yeah.
So keep 26.
Yeah, because she could have, her water could break and she'd not be in labor.
Gotcha.
Keep 26? Yes.
Okay, well, I don't know, maybe we should put 36 and 5. Because what if she's not
That's
in
exactly
labor
what I just said.
with absence of labor?
No, it's not going to be premature rupture of membranes if she has labor. There isn't anything before 37 and 0 except 36 and 6.
Somebody said 36 plus
I
5.
had a water break at 36 and 6 a few months ago, and she went into labor at 37 weeks.
Yeah.
And at the time, I did not consider myself in violation of the statute by attending her birth at 37 and 0, but I would have had to refer her the day before when her water broke, even though she wasn't in labor.
Yeah, that's what
But, I mean, if somebody has 36.5 and ruptures their membranes, I mean, most people would think that that's a good time to deliver the baby and not wait until they get infected necessarily.
Let's
So,
save that
Or
conversation
to
for
keep
another
them
day.
from getting infected.
Right.
Which we did. But
She had a
Yeah,
baby
so-
less than 24 hours
she had her
after the
baby
water
less
break.
than 24 hours after rupture.
again, but I'm just saying that premature rupture less than 37 weeks, in theory, less than 37 weeks, you're not going to be doing the delivery.
But in practice,
It's just a question about the last day.
because
The last day.
if you break your water the day before your 37 completed weeks, and you go into labor that night, and you're 37 weeks, why did we refer you?
You get referred back.
Well, that's the term.
No, because
You examine by
I think this is going to be a great
That is
exam
not a
question at some point. I say, it sounds like we need to keep it because there are occasions where there's a rupture of
Right.
membrane without labor.
Yeah.
And so we move on now to 27. Pregnancy with
You
non-reactive.
can keep that.
Okay. 28 will be deleted.
do we need abnormal amniotic fluid assessment in addition to oligo and polyhydramnios?
No.
No, it's redundant.
So then, non-reactive stress test and or abnormal biophysical.
So strike
Or
strike
we already have that.
for amniotic fluid assessment.
Yeah.
It's covered under 21.
Great. 29, other known diseases arising from the pregnancy.
Significant?
So vote for significant back here.
Yeah, other known significant disease.
Comment?
I have two questions.
Can you identify yourself?
Yeah, my name's Chelsea Grove. I'm a licensed midwife. My assumption is that these all apply to women who have never seen an OB. So if a woman comes into our care after being in care of an OB, she does not have to do this because it's considered she's already been consulted and examined for these things.
We are assuming that those women existing.
Well, the selection criteria. The selection, all of the stuff in the health history. So if she comes into our care and you discover anything in Part A and she's coming from obstetrical care, does she have to go back for a consult for any of these things to continue midwifery care, or is the assumption she's already been determined to continuing normal pregnancy.
You're gonna have to refer back.
If the OB said that to her,
Right.
you don't know why she left it there, so
Right.
if her OB said that to her, then you have to consult, but if you don't get that history, if she was left because she was dissatisfied, then you don't know, then you just wouldn't apply.
Okay.
That's my opinion.
Okay. So irrespective of prior care with the OB. Okay. And then question number 2, I raised this morning at our general meeting, and I'm curious to ask it again. We have an assumption that there is going to be doctors who are going to render these opinions and these consults. Is there anything either within the medical board legal aspect or anything within ACOG in the bulletins they put out informing their professional doctors of what they'll be required to consult that will help motivate or inspire or encourage doctors to render these consults to be more collaborative with us?
We can't force it. All I can say is that midwives have been in practice a long time and have developed collaborative relationships in many, many cases, and that's still what will have to happen and continue to grow and develop. But no one can force any physician to take a referral or make these consults.
And then are these changes going to be submitted in ACOG bulletins to their constituency? And I just ask because sometimes I encounter doctors because I have no idea. No. So there's a high likelihood we're going to come in contact with doctors where we live that maybe have no idea of this information.
Well, what you're getting from the doctor is this condition likely to affect your pregnancy? My understanding is they're not requiring the doctor to write a note or to contact the midwife, but to consult with the woman who comes in and says, I have problems with vascular disease. Is that going to affect my pregnancy? How likely is that to affect my pregnancy? And then the doctor's going to document that discussion, whether the doctor knows or not what the issue is, and inform the woman who then will come
Let
back
me
to
read
midwife.
from the statute. Let me read from it. A licensed midwife may assist the woman in pregnancy and childbirth only if an examination by a physician and surgeon trained in obstetrics and gynecology is obtained, and the physician and surgeon who examined the woman determines that the risk factors presented by her disease or condition are not likely to significantly affect the course of pregnancy and childbirth. That's if one of these things on this list occurs and the referral is made. That's what the physician have to determine. We have made excellent progress.
Smiling.
So,
Merry Christmas.
yeah, I'm just so happy. I know we still have work to do, but it sounds like the history of preterm birth is going to be ripe for discussion. And so, I ask that be on the top of the list for CAM and ACOG and other interested parties to revisit while I work on modifying the language. I suspect that MEDEX will be a further discussion, but within the context of what we discussed today. We are at 4:27. So we still have the hospital transfer form to discuss.
Can I make a request on this? It just,
Yeah.
I don't think we realized that this was on the agenda for today, and this is something Lori Gregg has put in a huge amount of time on,
Right.
and we would really like to have Lori be able to input, and even if it's on a speakerphone or something, she couldn't attend, but I'm not sure we're completely prepared for that, and if you want to, we'll discuss this best we can, but Lori really is the expert, and she's done a lot of work on this. We'd like to defer to her if that's possible.
Can I just ask Rachel Hansen to describe, so that maybe you can bring it back to Lori, what our practice has been doing in limited circumstances with this form?
Just with the few transfers we've had this year, this form is in a slightly different version than what we had as a prototype before, but because the hospitals that we've been transferring to did not seem to have the form or know about it, we were carrying the form with us. I've been filling out the form with the information that I know, giving it to a staff member to fill in the name and license number of the doctor who received the transfer and confirming that what I put in looks correct to them, and then they copy it, give me a copy, and they can send it in. And that seemed to take care of the concern that a lot of the midwives have, that a form would be filled out about them that had questions like reason for transfer, and though there's here no checkbox for a midwife was an idiot, I think some midwives were concerned that that might be what would be written in by the hospital, or, you know.
Or even if it's just failed home birth, that's not appropriate thing to put in there either, right? Yeah.
I think that's why we now are in the process of developing a list. I'm wondering, since it's so late,
I'm not opposed to setting another interested parties meeting, but I wanted to put it out there for discussion because I'm going to stay for a while. If people came specifically to talk about this form, I didn't want to short shrift them.
I have a question, and I don't want to beat a dead horse, but I'm wondering how putting the woman's name on the form that comes to the medical board is covered under HIPAA. How are we addressing that? Do we have to address it because you're a governmental organization? I'm just wondering what the legality of the hospital releasing the woman's name to the medical board without her consent. How is that?
It's not going to the medical board, that's the page that goes to.
No, it's the page that only comes to the medical board. Yeah.
Well, if the physician can make a complaint against a midwife in a specific case and name the client's name, they don't have to have the patient's consent to make that complaint and name the patient.
There are exceptions under HIPAA for regulatory and law enforcement agencies. So for the people in this room, is there consent to postpone the hospital transfer form to another interested parties meeting?
No. Unless there are questions that you wanted to take back to Lori about our opinions.
But I mean, if there's something you'd just like to bring to my attention, I'd be happy to. I mean,
I don't see
you have a few minutes of
questions
something.
there.
If there's something specific, please let me know, either now or later.
I think one of our biggest concerns as midwives is that forms are going to be filled out about a transfer that we feel strongly needed to be done in the way we did it, and we would like some input on how the form is filled out, or at least a signature afterwards, or we understand that the people at the hospital have concerns about this being a burdensome thing for them, so that if they're not going to do it the same day, the doctor may not even be there. Some functionary of the hospital who's assigned to do this may not even be in the OB department. We don't know who's going to be doing it. And so perhaps the midwife could be called in at some time in the future to sign off on it.
I can tell you that the form that was being worked on by the various groups was much longer, and then the hospital association was forwarded a copy of the form at some point and contacted the board and said, this is not going to happen without going through the rulemaking process and having the hospital association have input because it's incredibly burdensome. And of course, we've had a couple interested parties meetings on this. They haven't showed up yet. But I expect that once it goes through the regular, it gets noticed and goes for the 45-day comment period, they'll put in their input to try to derail the process. But that's how it's gone through different forms, and we landed on this one now that we're still working on. Here.
My only comment today would be that we should, under reasons for transfer, none of these are reasons to transfer the baby after it's been born, and we need to include those, because sometimes the transport is just the baby. There's also
Nothing for the mom postpartum.
right, so we need to.
Okay, let's look at the statute.
Okay. The statute just says hospital transfers. I guess. And then
Well, again, it's not the epitome of clarity.
Perhaps the reasons for transfer to be added here could be the ones from the LMPA. Sorry.
That's where the ones that are here, that's where they came from, right?
Yeah.
That's where you pull them off of there. Because if we really want to be able to correlate them to where they are, why are we transferring them? The other, just kind of a typos, I think we want page 1 and page 2 sent to the California Maternal Quality Care Collaborative, not just page 1, because they need to see the reasons for transfer too. We just don't want them to send the third page.
You're right.
And there's other cleanup items that need to be done.
Can I make a comment on this one?
Sure.
I'm so sorry because I know I'm coming in at the end. My understanding is this is a quality assurance document. Is that correct? To ensure that there's proper transfer. Is that right?
Yeah.
So, I can imagine, and I've heard, physicians who refuse to talk to the midwife. And there's no indication here. It says physician, I don't want to talk to them, just tell them I'm not available. And their friend nurse is going to put physician unavailable. And I think that if the midwife is there with the woman, physician unavailable is not appropriate unless the situation is taken care of, before the physician gets there. I don't think physician unavailable is acceptable to not get a report on a patient.
For the physician to not take report.
To not take report.
I
think there
It's a
should be
euphemism.
refused or declined box. And I think that there's a concern that it's the hospital that fills this out completely and the midwife has no input. I don't understand why there's not a section at the beginning that says the reason for transfer, because other conditions may occur, and so I've just been in too many situations where one nurse tells another nurse, and then they don't know what the story at the end is completely different. It happens all the time. So we're trying to make sure that these women get good care. So they should have the real story from the perspective of the licensed midwife as well as the hospital. It's a process issue.
Can I comment on this? Since the new law was passed, I've been encouraging other midwives to be sure when they're doing the transfer to communicate that I'm required to speak to the physician. Here's my phone number. can have them call me back, or I can give my verbal report when I get there. And I find that that improves communication. Just to tell them, I'm required. Yeah.
And they
Anybody
still-
having problems with that approach?
Because they want to strike position
Also, like Rachel, I take the form with me and I write on it myself, and they make a copy, so I do get some control at that point. There's a place that says other, and I can write the doctor would document it.
You don't send it to the board.
No, but they're getting the form from me, I'm getting the Xerox of it, and I've already written that on it.
Yeah, correct me if I'm wrong, Carrie, but there's nothing in statute that would permit the board to give a regulation that says the midwife should fill out her portion of it before she, and give it to them.
Well, it says using a standardized form developed by the board. But yeah, I mean, we could perhaps create a section, but the statute doesn't give us the authority to require the midwife to complete it.
Right, that's
I
what I
Or
think it's
to
a
require
great
the doctor.
recommend.
It's the hospital that's required, right? This is a
Yes.
hospital
Yes.
function, so it's,
Yes.
I mean, I don't know how you legislate who in the hospital does it or whatever, but, I mean, that's a hospital function that each hospital, I assume, can figure out internally how they do it.
You know, they could delegate it to the ward clerk if they want it.
And they do this for transfers from outpatient surgery centers.
Not this.
No, they do a similar, that's where we found from in the legislation, was we were trying to mirror what they already did, and it's routine for them. So to fill out a form in that situation.
So the form gets filled out, the midwife has her documentation and labor as for the reasons for transport. And they can choose to get that from her verbal report, from her medical records, and then they fill this out. And do the records go with this?
No.
You mean, do the records come with this to the board?
No.
They do not.
I think as we craft this form, we want, I mean, the whole point was, I believe, to be able to say, look, we've got this many transfer forms that midwives are reporting, 50 more transfers than we've got forms for. So what's that about? To kind of correlate data. And so if we end up with a form like this that's similar to our reporting tool, we'll be down the road trying to redo it 100 times, and that doesn't serve anybody. So I'm wondering if could we copy the form that comes from, or at least in theory from the outpatient surgery centers? I've never even seen a copy of that to know whether we're close or not.
Yeah, if I can say, because this was really given a little bit of attention legislatively, and it's showing, apologies for the group. And so I think what Carrie's saying is there's a lot of legal requirements or limitations on what can be put on the form, because we were so brief in what we said in legislation. But again, we can go back, if we need to put something in place for now, and then we go back and revisit what are we trying to accomplish with this form. And I think it was a combination of things, of cross-checking against the annual report, and also to look at quality. And it seems like, for instance, there are places where it seems as if the collaboration works well. I think, for instance, with Dr. Burns and Santa Clara, are there pockets where there are problems that then can go and look and see if there's a communication issue there. But so it looks like that we might have to take multiple attempts, runs at this.
I get that. I'm just thinking it's going to be difficult to know if the hospital is the only one that's filling the form out and sending it in, whether or not the data is accurate that they're reporting. For instance, if 10 midwives have 10 transfers to the same hospital and the doctor will never talk to them, but yet the hospital is just marking physician unavailable, that doesn't give the board any data at all to go back in and say, and do anything. We don't know why the doctor was unavailable. Maybe he was in surgery. Maybe he really just didn't want to talk to the midwife. And so I guess I'm trying to pre-think what those situations might be so that as we craft the form, we end up with fewer things we need to go back and amend rather than more.
Should we take it back to the MAC for some of these issues in terms like the neonatal stuff, postpartum stuff, a part where midwife makes a short summary, like 3 lines, 4 lines, something like that.
I think it could take up a lot of time at the map. I think
What else are we doing at the MAC?
Before we take it to the MAC, we need to get a little bit closer.
right, and I need to, do a specific reach out to the hospital association to try to get them to hear